Hello Year 12s and welcome to this video on the Tasmanian Dam Case. There are three things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. The third thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should write in your summary books. On this slide, I've set out the learning intention for this video. Make sure that you write this learning intention down in your Cornell notes. As a result of watching and taking notes on this video, you should be able to discuss the significance of the Tasmanian Dam Case, including its impact on the division of lawmaking powers. The Tasmanian Dam Case is also known as the Commonwealth against Tasmania. Our learning intention focuses on the significance of the Tasmanian Dam Case. But to understand the significance of this case, we must first look at the facts of the case, the issue that this case raised, and the High Court's decision in the case. Turning then to the facts. Back in 1974, the Commonwealth Government signed the United Nations Convention concerning the protection of the world cultural and natural heritage, which is also known as the World Heritage Convention. The Convention is an international treaty, that is, it is an agreement between a number of countries. The World Heritage Convention required these countries, including Australia, to protect World Heritage Areas, which are areas of major environmental significance. The United Nations Educational, Scientific and Cultural Organization, UNESCO, is the international agency that administers the World Heritage Convention. In 1981, the Commonwealth Government requested UNESCO to list the Franklin River in Tasmania as a World Heritage Area because it was a wilderness area that supported a diverse range of animals and plants. UNESCO listed the Franklin River as a World Heritage Area in 1982. However, the Tasmanian government wanted to build a dam on the Franklin River to use the water from the river to generate electricity to meet Tasmania's power requirements. Accordingly, in 1982, the Tasmanian Parliament passed the Gordon River Hydroelectric Power Development Act, which authorised the construction of a dam on the Franklin River. This dam would have flooded much of the wilderness area that had been listed as a World Heritage Area under the World Heritage Convention. The Tasmanian Act that authorised the construction of the dam was made by the Tasmanian Parliament exercising its residual lawmaking power. Remember that the only lawmaking powers that the Commonwealth Parliament has are those which are given to it by the Constitution. Now, there's nothing in the Constitution that gives the Commonwealth Parliament the power to make a law about a dam in a state. Instead, only the Tasmanian Parliament has the power to make a law about a dam in Tasmania. This is why, in making the Tasmanian Act, the Tasmanian Parliament was exercising its residual lawmaking power. Nevertheless, in 1983, the Commonwealth Parliament passed the World Heritage Properties Conservation Act. This act prohibited construction work in a World Heritage Area. In other words, it prohibited the construction of a dam on the Franklin River. You can see then that the Gordon River Hydroelectric Power Development Act and the World Heritage Properties Conservation Act are inconsistent with each other. The Tasmanian Act authorised the construction of a dam on the Franklin River, but the Commonwealth Act prohibited the construction of a dam on the Franklin River. The Tasmanian government was not very happy about this, and so it challenged the validity of the Commonwealth Act in the High Court. The Tasmanian government argued that the Commonwealth law was not valid because the Commonwealth Parliament had no power to make that act. Instead, the Tasmanian government argued that the power to make a law about a dam in a state was a residual lawmaking power, and so only the Tasmanian Parliament could make a law about the construction of a dam on the Franklin River. The issue that the High Court had to decide was therefore, did the Commonwealth Parliament have the power to make the World Heritage Properties Conservation Act? Put another way, because all of the Commonwealth Parliament's lawmaking powers are derived from the Constitution, the issue was whether there was any provision of the Constitution that gave the Commonwealth Parliament the power to make the World Heritage Properties Conservation Act. The High Court decided that the Commonwealth Parliament did, in fact, have the power to make the World Heritage Properties Conservation Act, because that act was a law about external affairs, and the Commonwealth Parliament had the power to make a law about external affairs because Section 51(29) of the Constitution states that the Commonwealth Parliament can make laws about external affairs. In coming to this decision, the High Court gave a very broad meaning to an external affair. It stated that an external affair includes any matter that is covered by an international treaty that has been signed by the Commonwealth Government. In this case, the World Heritage Properties Conservation Act was a law about external affairs because it implemented Australia's obligations under an international treaty, that is, the World Heritage Convention. As one of the High Court judges, Justice Mason, wrote in his judgment on the case, if a topic becomes the subject of international cooperation or an international convention is an international treaty, then it is necessarily international in character. The existence of the cooperation and the making of a convention establish that the subject matter is an appropriate vehicle for the creation of international relationships. That is, the existence of an international treaty means that the subject matter of the treaty is an external affair. The effect of the High Court's decision is that even if the Commonwealth Parliament does not ordinarily have the power to make a law about a matter, for example because that matter is covered by the residual lawmaking powers, if the matter is covered by an international treaty that has been signed by the Commonwealth Government, then that matter is an external affair, and so the Commonwealth Parliament can make a law about that matter. So you can see that because the High Court gave a very broad interpretation of an external affair as any matter that is covered by an international treaty that has been signed by the Commonwealth Government, then the Commonwealth Parliament's lawmaking powers have been significantly increased. While the Commonwealth Parliament can't make laws about a matter that is covered by the residual lawmaking powers, if that matter is covered by an international treaty that has been signed by the Commonwealth Government, then the Commonwealth Parliament is empowered to make a law about that matter, because the existence of the international treaty means that the matter is an external affair, and Section 51(29) of the Constitution gives the Commonwealth Parliament the power to make laws about external affairs. Because the Commonwealth Act, the World Heritage Properties Conservation Act, was valid, we now had a situation where a Commonwealth Act prohibited the construction of a dam on the Franklin River, but a state act, the Gordon River Hydroelectric Power Development Act, authorised the construction of a dam on the Franklin River. These acts are clearly inconsistent with each other. As a result, the High Court declared that Section 109 of the Constitution applied. Because the Tasmanian Act, the Gordon River Hydroelectric Power Development Act, was inconsistent with the Commonwealth Act, the World Heritage Properties Conservation Act, the Commonwealth Act overrode the Tasmanian Act to the extent of that inconsistency, and so it was prohibited to build a dam on the Franklin River. We can now look at the significance of the Tasmanian Dam Case, which is the focus of our learning intention. In a SAC or exam question, it is the significance of this case that you must focus on. Where an exam or SAC question requires you to explain the significance of the Tasmanian Dam case, you must not just describe the facts of the case. In fact, at the most, you should only briefly describe the facts. Instead, the focus of your answer must be on the significance of the Tasmanian Dam case, which is what this slide is about. The significance of the Tasmanian Dam case is that the High Court's interpretation of the meaning of external affairs increases the lawmaking power of the Commonwealth Parliament at the expense of the state parliaments. Now you need to be able to explain why this is so using the following chain of reasoning. First, where a matter is within the residual lawmaking powers, only the state parliaments can make a law about the matter. Second, if, however, the Commonwealth Government signs an international treaty which covers that matter, then the matter becomes an external affair. Third, because the matter has become an external affair, the Commonwealth Parliament can make a law about the matter. As a result, the Commonwealth Parliament's lawmaking power has increased because the Commonwealth Parliament now has the power to make a law about a matter that previously only the state parliaments could make a law about. And fourth, Section 109 of the Constitution applies so that any Commonwealth law that the Commonwealth Parliament makes about the matter will override any inconsistent state law to the extent of that inconsistency. As a result, the state parliament's lawmaking power has been reduced because the Commonwealth law overrides any inconsistent state law. It's critical that you can explain this chain of reasoning, so please make sure that you practice explaining it in your own words. Include a summary of this chain of reasoning in your summary books. The increase in the Commonwealth Parliament's lawmaking power as a result of the High Court's broad interpretation of the external affairs power has been underpinned by an increase in the number of international treaties that are being signed by the Commonwealth Government, and therefore an increase in the number of matters that are considered to be external affairs and about which the Commonwealth Parliament can make a law under Section 51(29) of the Constitution. Indeed, the external affairs power has been used to support a range of Commonwealth laws that implement Australia's obligations under treaties that have been signed by the Commonwealth Government, even though the matters covered by those laws would normally be covered by the residual lawmaking powers of the state parliaments. I've given you two examples of such cases on this slide. In Kuata and Bjelke-Petersen, the High Court decided that the Commonwealth Racial Discrimination Act 1975, which prohibited racial discrimination, was valid because it implemented the International Convention on the Elimination of All Forms of Racial Discrimination. That is, by implementing an international treaty, the Commonwealth Act was a law about an external affair, and so it was a law made by the Commonwealth Parliament in the exercise of its power to make laws about external affairs under Section 51(29) of the Constitution. In that case, this meant that there was an inconsistency between the Racial Discrimination Act, which prohibited racial discrimination, and a Queensland law that restricted the transfer of land to Indigenous people. As a result of this inconsistency, Section 109 of the Constitution operated so that the Racial Discrimination Act overrode the Queensland law. This was despite the fact that laws regulating the transfer of land within a state are within the residual lawmaking powers of the state parliaments. In Croom and Tasmania, the High Court decided that the Commonwealth Human Rights Sexual Conduct Act 1994, which protected the rights of consenting adults to engage in sexual activity in private, was valid because it implemented the International Covenant on Civil and Political Rights. That is, by implementing an international treaty, the Commonwealth Act was a law about an external affair, and so it was a law made by the Commonwealth Parliament in the exercise of its power to make laws about external affairs under Section 5129 of the Constitution. In that case, this meant that there was an inconsistency between the Human Rights Sexual Conduct Act, which protected the rights of consenting same-sex couples to engage in sexual activity in private, and the Tasmanian Criminal Code, which was a Tasmanian act that made engaging in homosexual acts a criminal offence. As a result of this inconsistency, Section 109 of the Constitution operated so that the Human Rights Sexual Conduct Act overrode the Tasmanian law. This was despite the fact that laws about crimes are within the residual lawmaking powers of the state parliaments. In fact, the external affairs power has also been used to support Commonwealth laws about matters of international concern, even where the matter is not covered by an international treaty that has been signed by the Commonwealth Government. So, for example, the Commonwealth Parliament has made laws about the trial and punishment of Australian residents who committed war crimes during World War II while outside Australia. Laws under which it is an offence for an Australian resident to have sex with a child outside Australia. And laws about the return of children abducted from Australia as part of a custody dispute. These laws do not implement an international treaty that has been signed by the Commonwealth Government, such as the World Heritage Convention that was considered by the High Court in the Tasmanian Dam Case. However, the subject matter of these laws, that is war crimes, sex tourism and child abduction in custody disputes, are matters of international concern and are therefore external affairs which the Commonwealth Parliament has the power to make laws about under Section 5129 of the Constitution. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to discuss the significance of the Tasmanian Dam Case, including the impact of that case on the division of lawmaking powers. Thank you for your attention.